Federal judges blocked this gerrymandered map, which limited black voting power, but Supreme Court justices let it stand. And here's why that's concerning. Alabama is nearly 27% black and account for 34% of the state's growth in the past 10 years. So will the fight for civil rights come down now to the highest court in the land? Right now, the court leans conservative, 6-3. In this case, Chief Justice John Roberts, the most powerful judge in the country, joined his liberal colleagues in dissenting the decision. But his vote wasn't enough to sway the court. Roberts siding with democracy on this case is shocking given his long history of being anti-voting rights. Early in his career as an aide, he was asked to make a case against the Voting Rights Act of 1965. As Chief Justice, Roberts dismantled much of the Voting Rights Act in the 2013 case, Shelby County versus Holder. He also sided with a Texas law that makes it harder for voters to prove they were victims of discrimination. And then there is Justice Neil Gorsuch, who makes it clear which side of America he represents. He voted to let Alabama disenfranchise black voters days after speaking at a Federalist Society event. Media were not allowed inside that event. And this organization was a pipeline for former President Donald Trump's judicial choices. And joining us now to weigh in on this issue is Elie Mystal. He's the justice correspondent for The Nation. And Elie, look, there's a lot of outrage and concern in the black community. On the surface, to you, what does this mean for other states perhaps looking to suppress the black vote?
It's open season. The Supreme Court has allowed racism to continue. This decision, I can't emphasize this enough. This is not like a Jim Crow decision. This is a Jim Crow decision. This is what the court did during the Jim Crow era. It is I'm not making an analogy, all right? This is actually the intellectual framework that allowed Jim Crow to happen, because what the Supreme Court said is that the amendments that we have that were passed to stop the apartheid government in the United States that existed before the Civil War, the 14th and 15th Amendments, cannot be applied to a racist gerrymander in Alabama because we are too close to the election. Folks, that's all it takes to reinstitute Jim Crow policies, is for the Supreme Court to refuse to apply the 14th and 15th Amendments against the states because of some cockamamie theory about states' rights. So what Brett Kavanaugh, Neil Gorsuch, and his buddies did was essentially make it so that nobody can challenge any racist map, not just in Alabama. Like, if we are we are in February of 2022, if we are now allegedly so close to the election that that this map can't be challenged, then no map can be challenged. And let's remember something: Alabama only released its map in 2021, on October 25th, 2021. They were sued November 15th of 2021. So they were sued as fast as possible. If as fast as possible isn't fast enough for Brett Kavanaugh, what that in fact means is that there is no way to challenge racist gerrymanders in this country, according to the conservatives. And just really quickly, do not give your boy John Roberts any credit here, because while he did side with the liberals on the procedural question of whether or not to uphold the district court's temporary injunction against the maps, he made it very clear in his opinions that when we eventually get to the merits, he will most likely rule that Alabama's racist maps aren't racist enough for John Roberts. And that's what Roberts does. That's what Alito does. They basically say that they make the standard, is it so racist that it bothers them? And if it doesn't bother them, then guess what? The states are allowed to do it. So we're in a real bad situation here.
Elie, we talked about the procedural piece of this. Why did the court decide to even pluck this case and hear it, given that they're not really on schedule right now?
I mean, if it walks like a racist duck and quacks like a racist duck, maybe it's a racist duck, because there is no other good reason for the court to have done this. They have extended a case. It's a 2006 case called Purcell v. Gonzalez, which said that you can't change the law too close to an election. But that was September, before an election in November. The court used it a lot during COVID in 2020 to say that you couldn't change laws to make voting more accessible during an outbreak. That's how conservatives rolled in 2020. But again, we're talking about changes that were taking place in August or September ahead of a November election. This is February. And again, this Alabama map was challenged as soon as reasonably possible after the map was promulgated. So for the court to go in and say that now we are in the penumbra of the election, remember, the same side here, the same Republicans making this argument, also decided that Amy Coney Barrett could be confirmed to the Supreme Court to be the fifth vote in this, in this racist, this white supremacist court. They decided that she could be confirmed, after the election had literally already started to replace the man who appointed her. So the hypocrisy runs deep with these people. The cynicism runs deep with these people. But so does the racism, right? So does the permissiveness of racist state laws. As long as we allow, and so you were talking earlier, you guys, about congressional legislation to overcome these laws. There is no congressional legislation that can overcome 5 conservative justices or 6 conservative justices on the Supreme Court. You can't get it done throughout Congress. If you let these people control the country, this is the racism that you will get.
And Elie, let's be quite clear here, as we have been. You've already pulled the layers of the onion back, you've peeled it back, and it stinks. And really, if you're someone who cares about democracy, it makes you cry. The bottom line here is that it already appeared that the fix was in. Going back to the selection of these conservative judges, the fix was in. Going back to the congressional legislation about the John Lewis Voting Rights Act and the Freedom to Vote Act, and the fact that 2 Democrat senators, Kyrsten Sinema and Joe Manchin, pushed back on getting it passed. So there's no remedy at this point in time unless you're going to have another bloody Sunday.
Right. Biden has said, oh, we have to out-organize, right? And I think about my mother, who was born in 1950 in Mississippi. You can't out-organize Jim Crow, right? If they don't let you have a voice, you can't organize your way around that. What's happening in Alabama, they have 7 districts. At least 2 of them should be majority-minority districts based on population. They're only letting 1 district be majority-minority based on population. So they've cut by half Black representation in Congress in Alabama, period. There's no way to out-organize that. There's no way to rise up against that. They have set the rules of the game against free and fair and full participation in elections. And again, we have seen this before. We know what the game is. We know what the playbook is because it's an old playbook. It's something they've run before. They're just doing it again with slightly different words. And I'm being generous by saying slightly different words. The logic is exactly the same as it was before. I don't know what to do about that. You rise up against that, or you accept it, but we're beyond the point of clever lawyer legal workarounds. There's no clever legal workaround against the Supreme Court that is arrayed against fairness and equality.
Well, Elie, this is something you've mentioned before, and doubtful that this will happen in the next few months, but still an option for Democrats to consider: expanding the court. Elie Mystal, Justice Correspondent for The Nation, thanks for joining us.